Last October, my daughter asked me a question I was not ready for. She was sitting at the kitchen table with a box of crayons and a piece of construction paper, drawing what she told me was going to be a family portrait for her third grade class. She had drawn me on the left side, small and careful, with brown hair. She had drawn herself in the middle with pigtails. Then she put down the orange crayon and she looked at the paper for a long time. "Mama," she said, "Mrs. Calvert says we have to draw our whole family, but Grandma Rose said I don't have grandparents." She said it the way 9-year-olds say things that grown-ups have taught them, not quite understanding the weight of it, trusting it to be true because an adult said so. I held very still. Then I asked her when Grandma Rose had told her that. She told me. And the date she gave me is the reason we ended up in a courtroom 6 months later, and the reason a judge read my mother's text messages aloud in front of everyone in that room, and the reason none of us left that hearing the same way we walked into it. I want to tell you exactly what was in those messages. But that part belongs at the end, where it happened. So stay with me. What she said was not something you can unhear. And the judge's face when she read it, I'll get to all of it. Welcome back to Calm Drama Stories, the place we tell quiet stories about ordinary people who faced extraordinary things and found their way through without losing who they were. If you've ever watched someone try to hurt you through your child, if you've ever had to sit across a table from the people who raised you and see them clearly for the first time, this one is for you. Sit with me. Because the part where the truth finally lands is worth the wait. Subscribe before we go any further, and then let's get back to it. My name is Nadia Calloway, and I was 32 years old when my parents declared war on my daughter. I want to start before the war, because the war makes more sense if you know what came before it. I grew up in Calder Creek, Tennessee, the younger of 2 children, and the one who had never quite learned to fit my parents' image of what I was supposed to be. My older brother Marcus was the one who came back to Calder Creek after college. He worked at our father's hardware business and lived 4 streets over and had 2 children and a wife named Sue, who made our mother's recipes the way our mother taught her to make them. He was the template. I was the variation. My parents, Douglas and Rose Calloway, are not cruel people in the ordinary meaning of the word. I want to be careful here because getting this right matters more than making them easy to hate. They are people who believe, with a sincerity I do not doubt, that there is a correct way to live and that deviating from it causes harm. My father worked the same hardware business for 34 years. My mother taught Sunday school for 28. They gave generously to the church restoration fund. They brought food to neighbors after surgeries. They were, inside the world they had built for themselves, genuinely good. The trouble was always when someone they loved tried to live outside that world. I left Calder Creek at 22 for a paralegal program in Nashville. I came back at 26, which pleased them. I took a job at a small family law firm in town, which was acceptable to them if not exactly what they'd pictured. I met a man named James Calloway. I kept his name after we divorced because by then it was my daughter's name too, and I saw no reason to subtract myself from her, and we married at 28, which they approved of. We separated at 30 when it became clear we had built something that worked on paper and not in the room, and we divorced at 31, which they did not approve of at all. The divorce was quiet and mutual, and handled like the legal professionals we effectively were. James worked in contracting, and had his own practical understanding of agreements and terms. We had one child, Eleanor Rose Calloway, who was 7 when we separated and who had my father's eyes and James's stubbornness, and a laugh that could fill a room she was not yet big enough to fill. Eleanor, I call her Ellie. She called herself Ellie until she was 8, and then she decided Eleanor was more serious, and she would like to be called Eleanor please, said with the gravity of someone who had thought it through. She is that kind of child. James and I shared custody cleanly. He is a decent man and a present father, and if we failed as a couple we did not fail as parents, which is the only statistic that mattered to me. He took her Tuesdays and Thursdays and every other weekend, and he showed up for every school event he was told about, and he paid his portion of everything on time. We were cordial at pickup. We were, in the way of people who have chosen to prioritize a child over their own unresolved feelings, fine. Eleanor made us fine. That sounds like I'm giving her too much credit, but I'm not. A child who is easy to be in the same room with makes it easier to be in the same room with her other parent. Eleanor had opinions about everything, and stated them plainly, and moved on without sulking when the answer was no. She ate what was in front of her. She got herself ready for school with a degree of competence that amazed me given she was 7 when we separated and ate through the worst of the adjustment. She lost things and found them. She made friends and kept them. She was not, at any point in those first 2 years, a child who seemed broken by the divorce. She was a child moving through her life with her whole self, which was a relief and a gift, and a thing I did not take for granted for a single day. My life after the divorce was small and ordered, and genuinely mine in a way it hadn't been in a while. I had a 2-bedroom apartment on Birch Street, the second bedroom Aline's, painted the specific shade of yellow she had requested by tearing a picture out of a magazine and saying, "This yellow, mama, exactly this." I had a job I was good at, the family law firm where I had worked for 3 years, and where I understood the rhythms and the cases, and the way the work mattered to real people in real situations. I made $41,000 a year, which was enough in Calder Creek with the particular discipline I had developed since I was a child watching my parents balance their accounts at the kitchen table. I packed lunches. I kept a running grocery list on the refrigerator. I called my parents on Sundays after church the way I had always called, and I drove Alina to their house for Sunday dinner the way I had always driven her, and I kept the peace the way you keep peace when you understand that the peace is for your child and not for you. I was good at keeping the peace. I had been good at it my whole life. My parents were less fine. The divorce gave them a language for every reservation they had ever had about me. I had chosen wrong. I had not tried hard enough. I had not considered Alina, which was the one that landed the hardest because I had considered nothing else. My mother in particular seemed to understand the divorce as a referendum on my character, a verdict she could now point to. She began calling more frequently, shorter calls, with a quality of surveillance in them that I could feel but not quite name. She asked questions about James, about whether we were truly not reconciling, about what I was telling Alina. I told her I was telling Alina the truth in language a 7-year-old could manage, which was that sometimes grown-ups who love each other decide to live in different houses, and that had nothing to do with how much both of her parents loved her. My mother said that was a very modern way to look at it. I said it was the way I was looking at it. The calls got shorter after that. Ellie loved her grandparents the way children love people who love them first, without conditions or history, with the simple certainty that Grandma Rose's kitchen smelled a particular way, and Grandpa Doug let her sit in the big chair, and the two of those facts were enough. She went to their house on Sundays the way she had always gone, before the divorce and through it, and I drove her there and picked her up and made sure to ask about their health and their garden and their Sunday school business, because whatever was happening between us, Alina was not the place to put it. That arrangement held for almost 2 years after the divorce. I want to tell you about the morning it broke. I had been at a difficult point in a custody modification case at work, the kind that stretches the hours, and I was running on 6 hours of sleep and too much coffee when my phone rang at 8:20 on a Tuesday in September. It was Alina's school. Mrs. Calvert, the third-grade teacher, asked in the careful way teachers ask things that are not quite administrative whether everything was all right at home. She said Alina had been quiet in a way she wasn't usually quiet. She said Alina had asked her very privately whether it was strange not to have grandparents. I said I wasn't sure what she meant, that Alina had grandparents. Mrs. Calvert said yes, she had said as much to Alina, and Alina had told her that her grandmother had said she didn't. I thanked her. I sat in my car in the parking lot for 11 minutes with the phone in my lap, then I drove to my parents' house. My mother was in the kitchen when I let myself in through the back door the way I had been letting myself in for 32 years. She was at the counter with her coffee, and she looked at me the way she looks when she knows something is coming and has already decided how to receive it. I asked her what she had told Alina. She set down her coffee. She said she hadn't said anything to upset the child. I told her what Mrs. Calvert had said. Every word. Calmly, because I had been in a law office for 6 years and I knew how to deliver facts without volume. My mother's face went through something I can only describe as calculation, and then she said the sentence I had not expected. She said, "Nadia, a child needs a stable family, and this situation you've created doesn't give Alina that." I told her the truth, which is that a real grandmother is part of a real family. I looked at her for a long time. "She's 9, I said. She drew a family portrait. My mother looked at her coffee. I only said what she needs to understand. I left. I drove home. I called James and told him what had happened, and he was quiet in a way James is rarely quiet, and then he said, carefully, that he thought we needed to document this. James was right. He usually was, on the practical matters. I sat with the phone in my lap for a few minutes after that call. Outside the apartment window, the street was doing its regular Tuesday things. A neighbor walking a dog, a delivery van idling, the ordinary machinery of an evening in Calder Creek. Alina was at James's that night, which meant I had the apartment to myself and the particular freedom of sitting with a hard thing in a space where no one needed to be protected from it. When she was home, I kept myself steady for her sake, not false, just regulated, because she read the adults in her life with the accuracy of a child who had learned early to pay attention. With her at James's, I could be something other than steady. I sat in that for about 10 minutes. Then I opened my laptop and I sat at the kitchen table and I opened the family text thread. The one my mother had named the Callaways, with a little house emoji 3 years ago, back when she still wanted people to believe we were the kind of family whose thread had a name like that. I scrolled back through 3 years of messages. I read things I had been skimming for 3 years, in a hurry, never looking too carefully. I was looking carefully now. I found 9 separate messages, across 14 months, in which my mother had made comments about Alina's home situation, my parenting choices, my fitness as a mother, and what she characterized as the instability I had created. Some were addressed to me directly. Some were to my father in the thread. Some appeared to be accidental inclusions, messages she had sent to others and perhaps added me to by mistake, or perhaps not by mistake. One of them, dated 7 months earlier, said something I read 3 times to be sure I had read correctly. I won't tell you what it said yet. That is the withheld part. I want you to hold the image of me at that table at 11 o'clock at night, with the house quiet and Alina asleep down the hall, reading that sentence on my phone screen for the 3rd time. Because the moment you hear what it said, you'll understand why a judge read it aloud in a courtroom 6 months later. And I want you to understand the shape of it first. I took screenshots, all of them. I saved them in a folder on my phone and then backed them to email. Because I am a paralegal, and I know what documentation is worth, and I know when you are standing at the beginning of something legal, whether you feel ready for it or not. I put the phone down on the kitchen table very carefully. Alina's drawing from the week before was still on the refrigerator door. A horse she'd drawn with purple legs and an unreasonably cheerful expression. She had given it a name but not written the name on the paper, because the name was private, she'd told me. Some things are just for you, she'd said, with the authority of someone who had thought carefully about privacy. I looked at that drawing for a long time. Then I opened my laptop and I started taking notes. I want to stop here for a second, because I know some of you are in this exact place right now. You've seen something you can't unsee about someone you loved, and you're sitting in the quiet of your house trying to figure out what to do with it. If you've ever had to make a decision that was going to cost you something you didn't want to lose, and make it anyway, leave one word below for me. Just one. I read them all. And subscribe if you want to hear where this goes, because the turn is coming and it's real. Now, back to it. The attorney I called was a woman named Patricia Voss, who had an office on Maple Street, and who had practiced family law in Calder Creek for 22 years. I had done paralegal work for a firm 2 towns over, and I had a general knowledge of the law. But I wanted someone with local practice and local courtroom history, and Patricia had both. She reviewed the screenshots I brought her. She read through them methodically, without expression, which is a skill lawyers develop and which I recognized and respected. When she finished, she set them on the desk and folded her hands. She said, "These are actionable." She explained the landscape. Tennessee does not have a statute that makes a grandparent's disparagement of a parent to a child automatically litigable, but it does have case law around interference with parental rights and the specific harm that documented pattern communication can establish. The screenshots, taken together, formed a pattern. The incident at school, documented by a teacher, added a real-world effect. The combination was something she could work with. She told me the fees. I wrote them in my notebook. $3,500 retainer, $285 an hour after that. I had $4,800 in savings. I had been careful for 2 years with the savings, the particular careful of a single mother who has looked at her margins closely. It was going to be tight. I said I would start with the retainer. She filed the initial paperwork 2 weeks later. A formal notice to my parents regarding parental alienation concerns and a request for a mediated agreement about their conduct toward Alina. It was the diplomatic option. It was the right first step. Patricia believed, and I agreed, that a letter from an attorney sometimes accomplished what conversations could not, that sometimes people behaved differently when they understood there were formal consequences. My parents called me the day they received it. My father first. He was quiet and stiff and said that he was disappointed I had chosen to involve lawyers in a family matter. I told him gently that the family matter had involved a lawyer because the other options had been exhausted. My mother second. She was not quiet. The call lasted 19 minutes. I did not record it, which I would later wish I had, though it would not have changed anything. She said I was trying to destroy her relationship with her granddaughter. She said I had always done this, created conflict, and then blamed other people for it. She said James had been right to leave, and Alina needed more stability than I was capable of providing, and that she was going to make sure the right people knew it. I wrote down that last sentence in my notebook after the call. Word for word, the way I had been trained to do. The right people. It was an open enough threat to be deniable and specific enough to be frightening. 3 weeks after the attorney letter, my parents filed a grandparent visitation petition in Calder Creek Family Court. I want to be honest about what that felt like, because I've told you I am not a person who dramatizes, and I won't start now. It was disorienting. Not because I hadn't considered it, Patricia had walked me through the possibility, but because holding the possibility in your mind is different from holding the filing in your hands. It is one thing to prepare for something. It's another to see it arrive. The petition claimed that I had restricted Alina's access to her grandparents without cause, that the restriction was harmful to her development, and that court-ordered visitation was necessary to protect the child's relationship with her family. It was written in the flat formal language of a petition, and it said things about me that were framed as concern for Alina and functioned as accusations. James, when I called him, said two things. First, we contest everything. Second, I'll pay half the legal fees. I have not said enough about James in this account, and I want to say this about him now. He was not required to involve himself. Alina's legal situation was not technically his unless he chose to make it so. He chose to make it so. He showed up to the first preliminary hearing and sat on my side of the courtroom and answered questions truthfully when asked, and said nothing grandstanding and everything useful. A man who could have stepped back and said this is between you and your family made it his problem because it was his daughter's problem. That is the only kind of man worth knowing, and I am glad Alina has him. My parents had an attorney too, a man named Harlan Gibbs who was older than Patricia and had a way of presenting things in hearings that made every reasonable boundary sound like a deprivation. He was good at what he did. I recognized it and resented it and tried not to let the resentment cost me anything. The first hearing was preliminary, status and scheduling. It lasted 40 minutes, and nothing was decided except a timeline and an order for both parties to submit documentation. I sat in the courtroom across from my parents, and my mother looked at the wall above my head, and my father looked at his hands, and neither of them looked at me directly. In the parking lot after, I sat in my car for a few minutes. My phone showed 2 texts from Alina, a photo of a drawing she'd done that afternoon at James's, a dog with a hat. Underneath it she'd written, "This dog is named Gerald and he is very important." I sent back a row of hearts. Then I drove home and worked on the documentation Patricia had requested. Alongside the screenshots, I had begun keeping a formal log. I had always been a note-taker, it was the paralegal in me, but now I was logging with intention, every interaction, every pickup, every comment. Dates, times, exact words when I could capture them. Alina said things sometimes at the kitchen table that landed in my notebook later, fragments of conversations she'd had at her grandparents' house that she repeated without knowing they were significant. I wrote them all down. The notebook was green, a narrow-ruled composition book I bought at the drugstore for $1.89. I wrote the date on the cover, and I started the first entry the evening I came home from my parents' house, after the conversation about what my mother had told Alina. I wrote the time, 6:44 p.m. I wrote the words my mother had said to me, in quotation marks. I wrote the words Mrs. Calvert had relayed, in quotation marks. I noted the date Alina said it had happened, which she had given me when I asked gently. I closed the notebook and put it beside my keys so I would not forget it was there. I wrote in it every day for 5 months. The entries were not dramatic, they were precise. Entry for a Wednesday in October. Alina mentioned at dinner that Grandma Rose had said her school project wasn't the kind of thing she needed to think about. I asked what project. She said the family portrait. I asked what Grandma Rose meant. Alina shrugged and said she didn't know that Grandma Rose had changed the subject to the roles. I wrote it down, all of it. Entry for a Saturday in November, pick up at parents' house at 4:30 p.m. Mother met me at the door. Eleanor came down the steps with her backpack and her shoes not fully on, hopping the last 2 stairs. Mother said, standing in the doorway, "She had a fine time, she's a good girl when she's settled." I wrote it down. That word settled appeared 7 more times in the next 3 months. In messages, in that one spoken comment at the door. Settled, meaning, here, not at yours. The argument assembled piece by piece without ever being stated outright. I also began to notice things in the text thread I had not paid full attention to before. The thread was still active. My mother kept posting in it. She was not a woman who understood that the thread was now evidence. Or she understood and did not care. I could not determine which, and it did not matter. She posted, and I screenshotted, and the folder on my phone grew. The mediation was scheduled for February. I had filed my documentation package with Patricia 2 weeks ahead of it, 47 pages including the screenshots, the log, Mrs. Calvert's written account from the school, and a letter from Eleanor's pediatrician confirming that Eleanor had expressed confusion and distress around family definitions at her last 2 well visits. The pediatrician was a careful woman and had worded it carefully. It was still damning in the flat way that factual things are damning. My parents' documentation package arrived through the legal process 3 days before mediation. I read it at Patricia's office. My mother had gathered letters from her Sunday school colleagues, from the church pastor, from neighbors, testimonials to her character, to her commitment to family, to what a devoted grandmother she had been before. As the letters variously phrased it, the situation arose. The situation. I read that phrase in 4 separate letters. The situation, meaning the divorce, meaning me, as if Eleanor's life had been a weather event and not a child's specific experience of specific people making specific choices. I want to tell you about the mediation because what happened in that room matters. Mediation is not a courtroom. It does not have a judge. It has a neutral third party, in this case a retired family court mediator named Mr. Elias Burke, who was 68, and wore the same expression throughout everything, which was the expression of a man who has heard all of it and remained unmoved by all of it, and was going to find a workable solution regardless. He was, in his patience, impressive. My parents wanted formal scheduled visitation. 6 days a month, alternating weekends, holidays to be negotiated. They framed it as what was best for Eleanor. I sat across the table from them for the first time since the filing, and I looked at my father's face, which was tired, and my mother's face, which was composed in the way she composed it when she was certain she was right about something. And I thought about the family portrait, Eleanor at the table with her crayons. The question she had asked in the voice she used for things adults had told her. I said no to the proposed visitation schedule. I said I was prepared to offer supervised visits at a neutral location, once per month, contingent on a written agreement about what could and could not be discussed with Eleanor regarding her parents' relationship, living situation, and family structure. My mother said that was insulting. Mr. Burke said he'd noted the position. My father said, and this is the moment I want to hold for you because it matters. He said, quietly, looking at the table rather than at me, that he had not wanted it to come to this. My mother looked at him. He looked at the table. I recognized it. I had seen it all my life, my father arriving at the edge of a true thing and then stepping back. He was there again, right at the edge of it. I will not wanted to come to this, which was the closest he had gotten to. Your mother went too far, and then he stopped. He looked at the table. He stepped back. My mother filled the space immediately. She said they had not come here to compromise their relationship with their granddaughter. She said the child needed them. She said things she had clearly rehearsed about stability and family and the importance of grandparents in a child's development, and they were not wrong things in the abstract. They were simply not about Eleanor. They were about her. Mediation ended without agreement. We were scheduled for a full hearing. I want to tell you about the 3 weeks between mediation and the hearing because those weeks were their own kind of hard. The case had cost $6,200 by that point. I had borrowed $1,400 from James, which I had put in writing because that is how I operate, and he expected nothing less. Patricia was thorough and prepared, and I trusted her judgment. I had done everything right on paper. But the paper version of right, and the experience of being a 32-year-old paralegal who knew exactly enough about family law to understand how these hearings could go, those were 2 different things. I was sleeping poorly. Not dramatically, not in crisis, just the particular restlessness of someone whose mind will not stop working through a problem that is mostly already solved. I would wake at 2 a.m. and lie still, running arguments, anticipating Harlan Gibbs's framing, imagining lines of questioning I might not be prepared for. I knew how these hearings could tip on presentation. I had watched them tip on less than what we had. I had watched judges make rulings that were technically defensible and practically wrong. I had watched good parents leave courtrooms with less than they should have. I did not think I was going to lose. I need to be clear about that. I thought the evidence was strong, and Patricia was prepared, and the law was on our side. What I could not stop was the part of my brain that had grown up in that house, that knew my mother's particular capability for appearing reasonable, that had watched her be believed by people who did not know her the way I knew her. She would sit in that courtroom in her good coat, and she would be articulate and warm, and she would frame everything as concern for Alina. And some part of me was awake at 2 a.m. calculating whether Judge Whitfield would see through the frame or see only the frame. I had a colleague at work named Beverly, who was 56 and had been a paralegal for longer than I had been alive, and who had a way of saying difficult things in a register so dry it took you a moment to understand you'd been comforted. Beverly had been watching the case from the sideline the way she watched everything, carefully and without commentary until commentary was useful. One afternoon she came to my desk with 2 coffees, set one beside my keyboard and said, without preamble, "The texts are going to do it. You've got the texts, that's the whole case, Nadia." I said I knew. She said, "I know you know, I'm saying it out loud so you can stop running the other scenarios." She went back to her desk. I sat with my coffee for a minute. Beverly did not offer comfort for comfort's sake. She had been doing this work for 31 years and she had seen cases won and lost, and she had a calibration that was worth trusting. If she said the texts were the whole case, it was because she had read the texts, and read the case law, and done the calculation herself, and arrived at an answer she was willing to put her name on. Beverly was right. She was almost always right. I stopped running the other scenarios. The night before the hearing, I went through everything one final time at the kitchen table. Alina was asleep. The purple horse drawing was still on the refrigerator where it had been for weeks, the horse with the name that was private. And tucked beside it, I noticed for the first time, was a second drawing Alina had added without telling me. I got up to look at it closer. It was the family portrait. The third-grade class assignment that had started all of this, the one Mrs. Calvert had mentioned when she called me in September. Alina had drawn it after all. She, pigtails in the center, me on one side, James on the other. And above us in a row, 4 round-headed figures with names written in Alina's third-grade handwriting. Grandma Rose, Grandpa Doug, Grandma Pat, Grandpa James, meaning James's parents, who had not complicated their love with conditions or agendas. She had drawn every one of them. She had always known exactly who her grandparents were. I stood at that refrigerator for a long time. Then I went back to the table and I finished my notes. The Calder Creek Family Courthouse is a brick building on Main that shares a parking lot with the library. I had filed paperwork in it dozens of times on behalf of clients, and I knew its corridors and its particular courthouse smell of old paper and floor wax, and the specific quality of morning light that came through the east-facing windows. I had never sat at the respondent's table in it. I sat at the respondent's table. James sat beside me, which he was not required to do and which said everything. My parents sat at the petitioner's table with Harlan Gibbs, who had a briefcase and a yellow legal pad and the settled expression of a man who had prepared well. The judge was the Honorable Karen Whitfield, who had been on the family court bench in Calder Creek for 11 years and who had a reputation in the legal community for 2 things. She did not like grandstanding, and she read everything. Patricia had told me both of those things and told me to be grateful for both of them. Judge Whitfield came in at 9:07. She had a folder. The hearing proceeded through the formal opening, the statement of the petition, the establishment of timeline. Harlan Gibbs presented my parents' case methodically, the long relationship between Alina and her grandparents, the Sunday visits, the evidence of affection, the character letters. He was professional and thorough, and he made my parents sound like the only adults in the situation who had Alina's interests at heart. Patricia's turn came and she was methodical in her own way, building from the school incident forward, Mrs. Calvert's account, the pediatrician's letter, the log I had kept for 5 months. And then she submitted the documentation package including the screenshots. She did not read them aloud. She submitted them and requested the court's review. Judge Whitfield spent 9 minutes reading. Courtrooms have their own silence, and this was the particular silence of a room full of people watching a judge read. My parents sat at their table, and my mother's composure held and my father looked at his hands. I watched the judge's face. I have a professional habit of watching faces in legal proceedings because faces tell you what the words are managing. Judge Whitfield's face was the practiced neutral of someone who has seen considerable things, and then, at a certain point in the reading, it was something else. Not dramatic. Just a small, controlled tightening around the eyes that a person not looking for it would have missed. She set the pages down, she looked at my mother, she said, "Mrs. Calloway, I'd like to read one of these messages into the record." My mother's attorney started to speak, and Judge Whitfield looked at him in a way that concluded that sentence. She picked up the page. She read the date first. 7 months earlier, a Thursday, sent at 9:48 in the evening. Then she read the message. I had read it many times. I had stared at it on a phone screen at a kitchen table at 11 o'clock at night. I had read it in Patricia's office when I first showed her the documentation, watching her face stay neutral with the skill of someone who has trained herself not to react in front of clients. I had read it in the car on the way to the courthouse that morning, one final time, because I am a person who checks her notes before a proceeding. I had read it so many times that the words had lost their particular charge for me, the way a word stops meaning anything if you repeat it long enough. Hearing it read aloud in a courtroom, in Judge Whitfield's flat, careful voice, in front of my parents and their attorney and James beside me and the court reporter at her machine and the fluorescent light over everything, that was not the same thing. There is a difference between a thing living on your phone and a thing existing in a room. In the air. In the official record. Becoming, as it was read, something that could never be unread. I watched my mother's face while the judge read. She had rehearsed for this proceeding. I could see the rehearsal in the way she sat, the composed angle of her shoulders, the expression she had prepared. And then the message was in the room and the expression held for exactly as long as she could hold it, and then it did not hold. The message said, "Alina would be better off if Nadia stepped back from the picture entirely. The child is stable when she's here and difficult when she goes back. James is the parent. Nadia is the problem. I've been saying it for years. Someday Alina will understand that herself." The courtroom was completely still. I had held that sentence for 5 months. I had shaped my whole case around it without quite letting myself feel the full weight of it, because feeling the full weight of it would have cost me the steadiness I needed to prepare. Now I let myself feel it. It moved through me like cold water, fast and clean, and then I set it down. My father, at the petitioner's table, had gone very pale. My mother said carefully that the message had been taken out of context. Judge Whitfield said, "I'd like to understand the context." There was no context. There is no context in which a grandmother writes to her own family that her daughter should step back from her own child's picture. My mother understood, in that moment, that the context she was being invited to provide did not exist. Her attorney put a hand on her arm. Judge Whitfield asked me one question directly. She asked whether Alina had, to my knowledge, ever been told by her grandmother that she did not have grandparents. I said yes. I gave the date, the source, the exact words Mrs. Calvert had relayed to me, because I had written them in a notebook and I still had the notebook. Judge Whitfield looked at the notebook when Patricia entered it into evidence. She leafed through several pages. She did not comment on the notebook directly, but she looked at it for a long time with the expression of someone recognizing a thing they recognize. Then she closed the folder. She made her ruling from the bench, which Patricia had told me was a sign the decision was clear-cut, rather than one that required extended deliberation. The grandparent visitation petition was denied. She noted for the record that the petitioners had not demonstrated that denial of visitation was harmful to the child's welfare, which is the legal standard. She noted that the documentation submitted by the respondent established a pattern of communication designed to undermine the child's relationship with her primary parent. She noted that a court-ordered visitation schedule with petitioners would require the court to trust them to behave in the child's interests, and the evidence before the court did not support that trust. She did not raise her voice. She was entirely calm. The calm was the point. She said one last thing before she closed the file. She looked at my parents, both of them, and she said, "This child has parents and grandparents who love her. That's a gift. What you do with it going forward is up to you." Then she closed the file and stood, and we all stood, and she left. In the hallway afterward, my father stopped me. My mother was ahead of us with Harlan Gibbs, already in motion, already finding the next thing to say. My father stopped and he stood in the hallway in his good court clothes, and he looked at me and his eyes were red at the edges the way eyes get when a person has been holding something back for a long time. He said, "Nadia." I waited. He said, "I didn't know she sent that message." I looked at him for a long time. my father Douglas Calloway, who had spent 35 years being steady and quiet and choosing not to know the things it cost him not to know. He was standing in a courthouse hallway telling me he hadn't known, and I believed him, and believing him did not change everything and changed something. I said, "I know, Dad," he nodded. His jaw moved once. He looked like a man who had more to say and no architecture for saying it, which was the man I had known my whole life. My mother called from the end of the hallway, "Roy," which was wrong. That is not my father's name. She calls him that sometimes when she is agitated. She means Doug, and he looked at me one more time and then he went to her. He would always go to her. That was the shape of him, and I had long since stopped trying to change the shape of it. What I had not expected was that knowing that clearly, without hope or argument, would feel like setting something heavy down. James was beside me by then. He said, "You all right?" I said I was. He said, "Ellie's going to ask how it went." I said, "Tell her the judge said everything was fine." He nodded. He understood what I meant, which was that Alina did not need the courtroom version. She needed the version for 9-year-olds, which was, the adults sorted it out, and you have grandparents, and everything is fine. Everything was, by the only measure that mattered, fine. The legal fees came to $7,800 final. James paid half, as he'd said. I paid the other half over 4 months, working the spreadsheet the way I had always worked the spreadsheet, methodically and without shortcuts. By June it was cleared and I filed the paid receipts and closed the folder in the way you close things that are over. The spring after the hearing was its own kind of quiet. Not empty, not heavy, just quiet in the way that follows something loud. I went back to work. I went back to school pickups and packed lunches and Alina's Tuesday nights with James and Thursday returns. The docket at the firm moved the way it always moved: new clients, new filings, new hearings. I sat across from parents in waiting rooms who were going through their own versions of impossible things, and I tried to do the work well because the work mattered to real people, and I knew that more than I had ever known it before. Alina went through those months, the way Alina went through most things, with forward motion and strong opinions. She had a science fair project about butterflies that consumed 3 weeks of our kitchen table. She learned to braid her own hair, a skill she practiced on me while I tried to read, with an intensity that left my scalp sore and my part crooked. She asked me once in the car on the way to school whether the judge had been nice. I said she had been fair, which is better. Alina thought about that. "Fair is better," she said, in the tone of someone filing information away. She did not ask anything else about it. She is that kind of child. She takes what she needs and moves forward. My parents did not contact me for 2 months after the hearing. The first contact was a card, in the mail, no note inside, just a card with a bird on it, a blue jay, Alina's favorite, and both their names signed at the bottom in my mother's handwriting. I put it on the refrigerator beside the family portrait. The second contact was my father, calling from the house phone on a Sunday evening, which I had come to understand was his register for the things that cost him something to say. He asked about Alina. I told him about Alina, her school project, the horse named Gerald on the refrigerator, the way she had decided at 9 years old that her middle name was perfectly good and people who went by middle names had character. My father laughed. It was a short sound, the kind he made when something got through his reserve before he could stop it. "She's something," he said. I said, "She is." He said, "She has your mother's stubbornness." I said, "I know." He said, "And yours." We were quiet for a moment. It was a different kind of quiet than the courthouse hallway. It was the kind of quiet between two people who are not pretending everything is resolved and are not pretending it isn't better than it was. He asked if they could take her to Sunday dinner sometime. The way it used to be. I said I would talk to Alina and see what she wanted. Alina, when I talked to her, said yes. She said she wanted to go. She said Grandma Rose made the rolls she liked, the ones with the butter on top, and she missed those. She said it simply, without drama, without any awareness of what it had cost to get back to a place where she could simply miss the rolls. I held that in the quiet of the car, her not knowing, me not saying. She missed the rolls. She was 9. That was the whole of it. I dropped her off at my parents' house on a Sunday in August, late summer, the yard still green, and the hydrangeas my mother kept by the porch still holding their blooms. Alina had her backpack because she always had her backpack, and she wore her yellow sneakers, and she ran up the porch steps the way she'd always run up those steps, because children's bodies remember places their minds haven't processed yet. My mother came to the door and she looked at Alina first, the way you look at someone you've been missing, and then she looked at me. Her face did the thing it does when she is trying to say something she doesn't have the direct language for. There was a second, just a second, where she looked very tired and very old in a way I had not seen before, and I understood that the hearing had cost her something too, not the same thing it had cost me, but something real. She said, "Do you want to come in?" Said, "Next time," she nodded. She understood what that meant, which was, there will be a next time and I am not ready for it today, and that is where we are. She did not push it. That was a change. That was, in the language of my mother, something. Eleanor went in. I heard her ask about the rolls from the front step, her voice already moving into the kitchen, already at home in the way children are at home in places that have always smelled the same. My mother answered from somewhere I couldn't see. And then the door closed, gently, and I stood on the front step for a moment in the summer quiet before I walked back to the car. The drawing is still on the refrigerator. The family portrait with the 4 grandparents and the round heads and the careful third-grade handwriting, each name spelled with the particular confidence of a child who knows exactly who she is talking about. Some things you don't take down when they're working. Eleanor has not asked me anything more about the court proceedings. Is not incurious. She is one of the most curious people I know, so I understand the not asking as a choice. She has filed it somewhere in herself as, the adults sorted it out, and now things are as they should be, and that is enough. I do not know whether, when she is older, she will want to know the full story. I will tell it to her if she asks. I will tell her exactly what I told you. She deserves the truth in the language she can manage, and when she is ready for all of it, it will be here for her. I kept the green notebook. The one from the kitchen table, the one with the dates and times and the exact words and the documentation that became a court record. I don't look at it often. I filed it in the cabinet where I keep the things that matter and that I hope to rarely need. But it is there. And on the page with the entry from the night I read the text message for the first time, the one at 11 o'clock with the house quiet and Alina asleep and the purple horse on the refrigerator, there's a small mark in the margin. Not a word. Just a line. The mark you make when you are reading something carefully and you want to be sure you don't lose the place. I never lost the place. That was the whole thing. I found every piece of it and I held it and I walked it into a courtroom and I let a judge read it aloud. I did not raise my voice. I didn't need to. The text said everything that needed to be said. Family, I believe, is the people who tell your child the truth about themselves, not the truth they want to impose on her, not a truth that serves their purposes, but the real truth, which is, you are loved and you belong and there are people on every side of you who will show up. Eleanor knew her grandparents. She drew them. She knew who they were before anyone made a courtroom question of it. She just needed someone to confirm what she already understood. I confirmed it. That is my story. One 9-year-old with a box of crayons and a question her grandmother had put in her mouth. One green notebook full of dates and times that turned into a court record. And one judge who read a message aloud in a quiet room and let the silence that followed do the rest. If the people in your life are saying true things to your children, hold them close. And if they're not, you already know what to do. Subscribe if this found you somewhere it needed to, and I'll see you in the next one.